All right. Let's say you started a business, you set up an LLC, you did all the right things. You've got your LLC, ABC, LLC. You've gone out and you've borrowed money, you've got some loans, you've got some business credit cards, you've got some trade debt, maybe you've got some suppliers, maybe you've got some independent contractors. And so there's all these business debts. The question now, maybe there's taxes that are owed, right? Now there's all these business debts. And the question now becomes, okay, if can I just put the LLC into bankruptcy and walk away? And the answer to that, of course, is it depends. It depends on a lot of things. Most notably, what is the debt? What's the nature of it? And did you personally guarantee it? And this is something that you need to be constantly vigilant for. In any documents you're ever signing is a personal guarantee. So you set up your LLC, which was a smart thing to do. Hopefully, you got a lawyer to help you with that to make sure you did it correctly, the right way, and that you're fully protected to the maximum extent you can be. Okay, you have that protection, but there are certain exceptions where you might not be protected. And of course, the reason you set up the LLC is to protect yourself from personal liability, but now we've got a few exceptions to that. So presumably, most of the business debts, uh, sure, with certain exceptions, sure, you could put the business into Chapter 7, wipe out the debts, except one, if you've signed a personal guarantee. And any loan with any bank, they're almost certainly going to require you to sign a personal guarantee. As a small business owner, single member LLC, there's no way that any bank is giving you a loan without you personally guaranteeing it and probably pledging some collateral, possibly giving a lien on your house, which now you've taken on significant additional risk if you've done that. Any credit cards, any business credit cards, almost certainly any credit card company is going to require a personal guarantee, and it's going to be there in that document. And I have so many clients that come to me and I ask them, hey, did you sign a personal guarantee? And they don't know. They don't remember. People don't know what they're signing and don't realize how much risk they're taking on. If you just signed a loan document, a credit card agreement, a lease, landlords have put this in this. I've seen this with trade creditors as well. You might have a supplier that's selling you products and they might slip a personal guarantee into their account agreement. And once you signed it, you have basically now waived any protections that the LLC gave you. So now if, God forbid, things go wrong, can't afford to pay, the company can't afford to pay its bills, you can't just walk away from the debt you've personally guaranteed. Now, anything where you didn't personally guarantee it, probably you can walk away from that. Somebody sues the company, doesn't sue you personally, or maybe the company just owes somebody money for work done, but there was no contract. Most of your basic debts, sure, that could get wiped out if the LLC, if you put the LLC into Chapter 7 and decide you just want to walk away. But any personally guaranteed debt, it's basically the same that as if you had taken that on personally. It's almost as if the LLC didn't exist. Now, of course, the LLC is the main borrower, you're just the guarantor, but if the LLC doesn't pay, immediately they're going to sue you on the personally guarantee. And you better respond to that lawsuit, because if you don't, what's going to happen is they're going to get a default judgment. If you just ignore the lawsuit, they'll get a default judgment on the personal guarantee. Now, once they've got a judgment, now they can file a lien on your assets, your home, garnish your bank account. You wake up one morning and your bank account's empty. If you ever find yourself in that situation, you need to talk to a lawyer immediately. So, would love to get you in here and talk about your situation.